A case that has captivated the country in recent times is the Ahmaud Arbery case. Perhaps we could use that as an example to talk through self-defense in the face of citizen's arrest.
Absolutely. So when Travis McMichael and his father and neighbor see someone, and they then decide, right, they see Ahmaud Arbery running, and they then decide that they are going to execute a citizen's arrest. Now, their account was that there had been previous felonies in the neighborhood, although that was disputed by the prosecution because many of these alleged crimes had never been reported. But their claim, of course, is we're going to act in the name of the state. We were going to arrest him. And therefore, we were using lawful force so that when Arbery sees these men pointing guns at him, it's not, they say, unlawful force. They're not the initial aggressors, is their claim, because they are legitimately entitled to engage in this behavior. Now, it turns out the judge ruled that that's not what Georgia law says, that in fact, they were not engaged in a legitimate citizen's arrest. Of course, this went to the jury to decide, but it ultimately turned on the question of what the citizen's arrest provision permitted. And the judge said that it had to be a felony that was committed within their presence or their knowledge. So it couldn't be something where they suspected someone had committed a crime, where they had probable cause to believe that, which would have been its own jury question. They actually had to witness a crime and the victim committing it in order for them to be executing an appropriate citizen's arrest.
And that was because they used deadly force or in general for a citizen's arrest under the Georgia law?
For any use of force, it had to be within their presence. Before under then existing Georgia law.
And you point out then existing, after the Arbery case, the Georgia legislature repealed that law.
That's exactly right. So now in Georgia, police officers who are outside their jurisdiction can sometimes use force, despite the fact that they're technically not police officers at that moment. They're not acting as lawful police officers. And in very limited situations, private citizens can use force when it's a Target or a Walmart and they see somebody committing theft, or a restaurant and somebody's running out without having paid the bill. They're allowed to use non-deadly force essentially to stop the person and detain the person, but they have to call the cops and they're only allowed to keep them for an hour.
So there still is a limited citizen's arrest provision under Georgia law, but not the law that was in place at the time of the killing of Ahmaud Arbery.
That's exactly right. And citizen's arrest laws can be just extraordinarily broad because we're talking about the question of whether somebody is entitled to a criminal defense, and we're not talking about the Constitution. Citizens can use more force than is constitutionally permissible. So in Florida, you can shoot a fleeing felon in the back if it's necessary under a citizen's arrest law, even though you're not allowed to do that as a matter of policing and constitutional law.
If I see someone in Florida break into my house and steal a $20 portable speaker and they're running away, I could be justified, or I wouldn't be prosecuted for killing them?
So potentially, depending on exactly how they're going to construe the burglary statute and whether that's going to count as the kind of felony, absolutely. When you use deadly force and you say, stop, I'm arresting you, and the person keeps running, you are executing a citizen's arrest, and therefore you would not be guilty.
Wow.
The way that the common law had been trying to rein this in, the way that states had been trying to rein this in, is exactly what happened in the McMichael case, which is they said, citizens, we may be authorizing you to do this, but you do this at your peril, in that it actually has to have been a crime that you saw. And in many jurisdictions, you have to have gotten the right person. So unlike police officers who have probable cause, if you get it wrong, you lose the defense. So in Georgia, the question wasn't whether or not Arbery actually had committed a crime. And there didn't seem to be evidence that he had committed the kind of felony that would have justified the use of force. But if in fact you're wrong on that, whether he committed the crime, whether there was a crime or whether he committed it, then in Georgia you absolutely lose the defense.